Alright, welcome back to Freedom Unchained channel. Continuing with Common Law School from George Gordon, Lesson 2, Part 2. If you guys haven't started from the beginning, go in the description and click on the playlist and start from the beginning. Before you guys jump into the middle here, make sure you understand everything from the beginning, because if you're not familiar with common law, then you need to become familiar with it, because it's not like what the indoctrination camps have taught you the law is. They have taught you how to be slaves, and now we're going to teach you how to be men. Or women, because woman's just a man with a womb. Please subscribe to the channel if you haven't already. Please comment, let's get a conversation started. Smash the like button. Share this video around to all your other slave friends that haven't become free yet. We're trying to get everybody out of this slavery that the government has created and have indoctrinated us into for generations. And we need to get back to freedom in America. So do share it around. Hit the bell notification so you'll get the next upload that I post. And let's get to it.
Number 18. Always repudiate any suggestion of a licensed lawyer or public defender at every opportunity, at every hearing, every time, and without fail. What the judges will do is they'll offer you a public defender. When a lawyer comes into the case, he's signed on as called, and he's called the attorney of record. You ever heard of power of attorney? Well, you know, when someone has your power of attorney, you're declared incompetent. And when you're incompetent, then your lawyer acts for you, and he represents you in that courtroom. Well, when that fellow is representing you in the courtroom, you are an incompetent. Now, if you're incompetent, then when your lawyer acts for you, he has jurisdiction. So when the lawyer enters the courtroom, that traffic court or that OSHA court has jurisdiction over the case. And you've lost your whole jurisdiction argument in one fell swoop. That's one major reason. The next major reason is 90% of the lawyers in this country are incompetent. And I know you're going to say, well, gee, that's just your opinion. No, that was the opinion of Chief Justice Warren E. Burger in 1977. He's the one that said that trial lawyers, not all lawyers, just trial lawyers, 90% of them are incompetent. My experience confirms that. I have met 3 or 4 good, competent trial lawyers, and all the rest of them are incompetent. I don't even claim to be competent. I'm just a citizen. So I'm not one of the competent, and I don't claim that. I'm just telling you that 9 lawyers out of 10 that you're going to come in contact with that do trial work are not competent. And therefore the odds are 9 to 1 against you when you go in to hire a lawyer. All right, so for those 2 reasons alone, and there are many more, and we'll get into those as we go along through the course on other issues and other topics and subject matters, you don't ever want that lawyer. And sometimes they'll trick you. They'll say, well, I'm going to appoint the public defender in this case because I've determined that you're not competent to move forward, Mr. Gordon. I've had that happen. Excuse me, Your Honor. You are going to appoint counsel for me? Yes. Let me ask you another question. Did you hold some hearing in an ex parte capacity to declare my incompetence that I wasn't there? Oh, wait a minute. Now the conversation starts to break down. Yeah, Your Honor, if you're holding ex parte hearings declaring me incompetent in the word of the state, I'd like to be present, and I demand all of my rights at all times, and I demand the right to face my accusers and to present evidence and witnesses in my own behalf. Yeah. Now, this is frivolous, Mr. Gordon. Your Honor, I think you're violating my rights, and if you're violating my rights, I want the record to clearly reflect that so that I'll have an appealable issue. Now, let the record clearly show that I'm acting impropriâ personam. I'm not here demanding a lawyer. As a matter of fact, I could hire F. Lee Bailey if I wanted it. The reason that I haven't hired Mr. Bailey is I haven't determined whether or not he's competent. Now, if you want me to interview Mr. Bailey, I'll be happy to interview him, sir. Here's another line that came down pretty well. One time he said, well, I'm going to appoint Klaus Wiebe anyway. And he threw that down. I'm ordering you to go in to Mr. Klaus Wiebe, and I'm appointing him as the attorney for the defense. Well, just let the record show that I object and that you're doing this in your capacity against my will and over my objection in violation of my right to due process and equal protection. Now the judge is outside of his jurisdiction. Now he's suable. Watch this. Don't ever get angry when judges do that. They're doing so out of ignorance. They don't know what they're doing. Jesus had something, you know not what you do. Now, I went into Klaus Wiebe and, gosh, this was really funny. I go in and I say, hi. There's always a secretary out in the front. Hey, my name is George Gordon, and I've been ordered by Judge Jablonski here to come in and interview my public defender. That's right. I'm here to interview my public defender. Would I want to hire somebody that I haven't interviewed? Do any of you people out there who are employers employ people without interviewing them first? You got a restaurant, don't you ask the guy if he knows how to cook? Don't you ask the guy if he knows how to fry an egg before you hire him? And so she was really offended at that. And I detected that, and I said, young lady, you seem to be offended at the suggestion that I would come in here to interview Mr. Wiebe. Now, I want you to understand that I'm not here of my own free will and volition. And these 3 witnesses that I've brought along with me are going to testify to that. And I'm going to put you on the witness stand, and I'm going to let you tell the court that I'm here against my will and over my objection. But Judge Domblowski over here, he ordered me to come in here, and he told me that he was going to appoint this office to represent me. And before I agree to that, I want to talk to my public defender, and I've got some questions here. I've got 114 questions here that I'd like to ask him to determine whether or not he's competent to handle this traffic ticket. Well, you could see the disgust and the disdain, and so she went inside and she got this fellow. We went in and we sat down, and he thought that was pretty funny that I was going to interview him. And so we all sat down around the desk, and he said, now, why did the judge appoint the public defender? Gee, I don't know. I can't imagine. Under Rule 14, I don't even qualify. I could hire F. Lee Bailey if I wanted him, but I don't think he's competent. Well, then, are you telling me that you've got money and you can afford to hire a lawyer? Oh, certainly. Yeah. Well, the judge can't appoint our office unless you're indigent. Yeah, I know. Well, what are you doing here? I don't know. I haven't got the foggiest notion. I don't want to be here. But I've got this court order, and it orders me to be here, and so here I am, and I'm here to interview you to see whether or not you're competent. Conversation broke down. Mr. Gordon, I'm a very busy man. This conversation is terminated. You go back to the judge and tell him that you don't qualify. Oh, now, excuse me, sir, I don't want you to get upset. I can see you've lost your composure. Would you like to take 5 minutes to regain your composure? Oh, if you don't think that blew his mind. He ordered me out of his office. Well, I'm going to leave, and I don't want you to get angry with me, Mr. Jones, but I just want you to understand the judge ordered me to come do this, and I don't want to do this, but he told, let me see that. And he looked at it, and I showed it to him. He shook his head, and he said, this is absolutely insane. Yeah, that's right, I agree. I think this is insane. But what did you want me to do? Did you want me to commit contempt of court? I'm going to put you on the witness stand, and I want you to testify that I came in to interview you. That's right. It's like I told you, if you're not having fun, you're not doing it right. Number 19, a public defender is qualified to do 2 things, plea bargain and lose. You show me a public defender who can win a case. I've been doing this for 5 years, and I've never seen a public defender win yet. Not once. I see them plea bargain, and I see them talk a lot and make deals and one thing and another, and I see them go into the courtroom and argue and wax eloquent and jump up and down, rant and rave, and paw the ground, bite the bushes, but I don't see them ever win any cases. I don't ever see the jury come in, not guilty. I've never seen that. I've never seen a judge say, I'm dismissing this case because this case is frivolous and without merit. You never saw that? If you know of any, why don't you write and let me know? That would really be interesting. I'd like to know about that. And that's why I put down here as rule number 19, a public defender is qualified to plea bargain and lose. And in every suggestion of a licensed lawyer, can he? If he's forced upon you, kick him out. Oh, and I'll tell you where to do it. Do it right in open court. Yeah, you walk into court and here's your public defender. I taught a drug addict how to do this one time when I was in jail. This funny, I've got to tell you this story. Crack you up. This guy's charged with 7 felonies. Dumb as a post. Hadn't got sense enough to pour water out of the boot with the directions on the bottom. I walked in there and I said, you want to win? You bet. Boy, I'm faced with life in prison. Yeah, that's right. I see that. Why don't you go in there and lay about 4 major constitutional federal questions on the judge? They won't be able to answer the questions because in this state, we haven't had a lawful conviction since 1895 because we don't have prosecutors here. We have prosecuting attorneys and public prosecutors. We haven't had those for a long time. And we've got actions by the state of Idaho and not the people of the state. And we don't have grand juries in our state. They did away with those about 20 years ago, and we haven't had any grand juries. Why don't you demand a grand jury pursuant to your Fifth Amendment right under the Fifth Amendment to indictment? And so I gave him a little coaching there, and I said, there's one more thing. So you got this public defender over here, you see, and you've already lost jurisdiction, so why don't you go back in and recover by motion? So I helped him. He wrote up about 5 or 6 motions, and he walked into the courtroom, and he said, Your Honor, I know how this came down because there was 3 other prisoners in there, and they reported back. He says, Your Honor, I have some administrative and procedural matters. And the judge looks over and rather surprised, you know. Well, what are they? Yeah, Your Honor, my public defender over here is incompetent, and he's not representing me in the capacity to which I believe that I should be represented. Some of my constitutional rights have been waived, and he went down the list of about 4 or 5, his right to a grand jury indictment, his right to a public prosecutor, his right to confront and cross-examine witnesses in the probable cause hearing, and blah, blah, blah. And he goes down through the list, and the judge is sitting over there going, oh, my God, no, this can't be happening to me. And, Your Honor, I want this public defender disqualified because he never wrote a single motion challenging these major federal questions, which are all violations of my rights. And therefore, these rights, having not been demanded timely, were waived. And since he's waiving my rights, I'm contending that he's incompetent and unqualified, and I want him dismissed from the case. And I'm going to handle my own case in propria persona, and I'm going to defend myself. That's right. Fire the dummy right in open court. It's twice as embarrassing for them that way. So there you have the 19 basic rules of a pro se. You read those and you study them and you get them in your mind so that no matter who you're talking to, as a matter of your character, what's your name? Who wants to know? What's your social security number? Are you going to send me a check? I'm going to appoint the public defender. Have you been holding ex parte hearings and declared me incompetent when I wasn't there without an opportunity to defend? You see the lines that you get in? And you get those lines in and on the official record, and then you motion that record up as evidence, and you keep that record as evidence in case you want to sue that judge someday. Now, I generally don't recommend suing judges. Remember, we're trying to go into the judicial branch of government to get redress of grievance, to fight off the offensive actions of our executive and legislative branches of government. But some of these lower court judges at the magistrate and traffic level, I'm telling you, they're so dumb. At the lower levels over there, I've actually seen them commit felonies right in the courtroom pursuant to citizens' rights. That's right, felonies under Title 18, Section 241. Do it every day. Dumb as posts. Never seen anything like them. Pick up this next page, and it's got 4 reasons why a pro se cannot be defeated. And right up here in the front of this 30-segment course of lessons, I'm going to show you one of the most valuable and potent tools that you're going to use right from the scene of the crime, right on through the traffic court, right on through the appeals process, and right up to those marble steps of the Supreme Court in Washington, D.C. Listen to this. Pro ses cannot be defeated. Here's why. The cost of a misdemeanor case to the court in a jury case is about $1,500 in this state. Just an average run-of-the-mill traffic ticket. You got caught going 50. 35-mile-an-hour zone happens to you every day, right? You've probably been in the courtroom a number of times and pled guilty and paid them the $35 and the $11 court costs or whatever it is, right? You know, that's a very profitable business out there for the traffic courts. And they like to run people through, and I've seen judges here. We have a particular judge in this jurisdiction who can run a person through every 30 seconds. That's right, every 30 seconds. So I'm going to go through why pro se's cannot be defeated. Listen to this. The cost of this misdemeanor will be about $1,500 in our jurisdiction. I had a judge one time tell me it cost $2,000 to run a case through. Our estimate is that it's really more like about $1,200. But it's going to run somewhere between $1,200 and $2,000, depending upon how many days the trial lasts. It can last a day, day and a half, 2 days. For this reason, the court and the prosecutors are careful not to tackle an experienced pro se litigant because the cost is usually 10 times the value of the fine or more. Money rules in this game. Now, in the last 2 years, I'd see if I can remember the last jury trial. I haven't attended a jury trial in over 2 years for myself. Now, I've been charged with 33 crimes in the state of Idaho in the last 5 years, and I've won all 33 of them on the courtroom floor. I've never been defeated on the courtroom floor. I had a prosecutor tell me one time that in 15 years he'd never defeated a competent pro se. Now, there are some citizens who come in a pro se capacity that are defeated. When we're talking about a competent pro se, we mean someone who knows how to read and write, someone who knows how to research case law, someone who can plead the complaint, someone who can attack the statute and can find out whether or not the law even applies to them. Most of the time, once you become competent, cases will be dismissed on motion of the prosecutor. That'll happen about 8 times out of 10, and about 2 times out of 10 the judge will dismiss for lack of a prima facie case on a technical move, at a probable cause hearing or a preliminary hearing, something on that order. They will throw it out of court. But remember that money rules in this game, and boy, when it comes to the traffic courts and all misdemeanors, they're just interested in making profit. And when they're faced with a $300 fine versus a $2,000 or $3,000 trial, they'll opt for any kind of plea bargain they can get. And, of course, what do we teach? Total victory or total defeat. You can dismiss any time you want. Well, this is too serious a matter, Mr. Gordon, and we just can't dismiss this, but we're willing to negotiate to a lesser plea. Oh, wait a minute, Mr. Prosecutor. Let me see if I understand this. You're telling me that driving 80 on the freeway or selling beer to kids or whatever these charges are is a pretty serious matter to you. Is that correct? Oh, yes, sir, Mr. Gordon, and I have a public duty. You know, I've sworn an oath to uphold the laws of the state of Idaho. You know, I agree with you, and I think you're right. And I really admire you, sir, for sticking by your guns and prosecuting these vicious and heinous criminals and citizens because they're selling beer to minors and they're driving 80 on the roads and they're tearing up their jail clothes. And I think that's really wicked and bad and terrible and awful. And I think you should move forward. Well, but Mr. Gordon, now we're willing to talk. I didn't say that we wouldn't negotiate. I think that any case that's important enough for my government to prosecute is important enough for me to defend. Now, by golly, if you're as sincere as you indicate to me you are about prosecuting this case, I want you to know that I'm just as sincere as you are about defending this case. But, Mr. Gordon, you know that this is going to cost $2,000. Well, no, I don't know that this is going to cost $2,000, Mr. Prosecutor, but, you know, there's 2 sides to the coin. If you're real concerned about the taxpayers' money and you're real concerned about justice and you don't want to waste $2,000, you could dismiss, couldn't you? Oh, but I've got this oath of office and I've got my duty and one thing and another to do. No. Oh, okay. I just wanted to make the suggestion to you in case it had slipped your mind that if you're concerned about the $2,000 that it's going to cost to prosecute the case, well, I just want you to know that I'm real concerned about it too. Now, you want me to plead guilty to save the $2,000, and I want you to dismiss to save the $2,000. Why don't you tell me where there's some common ground? Well, the common ground, Mr. Gordon, is if you'll plead guilty to disorderly conduct. You want me to plead guilty to disorderly conduct. Oh, I see. Well, wait a minute. How was I disorderly? What was it that I did that... Oh, well, Mr. Gordon, you weren't disorderly, but that's a lesser charge and has a lesser penalty. Oh, I see. What you want me to do is to go into the courtroom and lie. Is that what you're suggesting that I do? That I admit and plead guilty to something that I didn't do? be amazed at how often the conversations will break down. But don't miss your opportunity to talk to your local friendly prosecutor, because that's the kind of people you're dealing with. You see, he's sitting in here with his moral halo on, telling you that he has this duty to perform and he just wants to save the taxpayers $2,000. But he wants you to go in and lie and plead guilty to something you didn't do. Yeah, that's right. He's probably got a wife at home and a mortgage and a patch of lawn out in the front and a couple of dogs. And he's just an average run-of-the-mill suburbanite. He reminds me of these guys, at Auschwitz. Can't you just picture this? The guy comes in. Boy, I've had a hard day at the office, Marge. Gee, what was so hard about it today? Well, gosh, we killed 5,000 Jews today. And boy, if you don't think that's a lot of work. Wow. And we've got to work overtime on Saturday. The boss says that they're going to work us another 4 hours. Boy, am I tired. Boy, what's for dinner? These guys are so used to doing this that it's just done every day. They lie, they steal, they cheat, they cajole, they make deals, and they plea bargain. I'm not really sure that they understand truth from error. That's a fact. I'm not sure that prosecutors, after they've been doing this for a while, and I'm not saying, they're all like this. There may be some exceptions. But, I've talked to some prosecutors, and they want me to go in there and lie. And I'm sitting there going, why do you want me to lie? I'm telling you that I haven't even done what you're claiming that I've done, and now you want me to lie and go into court and tell them that I've done something that you and I both know I haven't done. Let's spend the $2,000 and let's go adjudicate this. And then you'll find out that, in the interest of justice, that's the way they word it here in Idaho. In the interest of justice, Your Honor, we've decided to dismiss. Number 2, the experienced pro se will file 15 motions per case, raising numerous constitutional issues that will force the litigated issue into years of appeals and expense that will demoralize the prosecutor, and nuisance value will win if the money issue doesn't. That's right. Now, did you want to go ahead and prosecute, sir? Now, my theory of the case is that the court has no jurisdiction. My rights have been violated. I've been denied due process of law, equal protection of the law, and I haven't had counsel, and so therefore I'm going to demand a struck jury, and I demand a jury of my peers and a jury of 12 pursuant to the common law, and I'm going to file about 15 motions, including right sua sponte, and pleading the complaint and arraignment and plea, and, on and on. I'm going to file all these motions, and I demand a grand jury indictment, and, the issue isn't any longer were you selling beer to kids. The issue is, why did you deny me my rights? That's the issue. Anything that's important enough for my government to prosecute is important enough for me to defend. And my contention in life is that I haven't violated these laws. I don't go out and challenge a law. This lady, this black lady down in Birmingham, and keep this in mind, the only way you can get in on the courtroom floor to argue an issue is if you break the law. I don't know if that's right or wrong or good or bad. I didn't make it that way. I got here on the scene in 1939, and that's the way the law was working in 1939 and 35 and 26 and 1890, and that's the way it works today. If you think a law is unconstitutional, or if you think the application of a particular law doesn't apply to you, the only way you can get in on the courtroom floor is to break the law. I would be happy to go in on the courtroom floor and argue the driver's license issue, but if you've got a driver's license in your pocket, then there's no issue. So what you have to do is send the driver's license back or let it expire and drive, and the policeman says, "Where's your driver's license?" "Don't have one." "Well, I'm going to cite you under Idaho Code 49-317 because you don't have a driver's license." "Oh, okay. Go ahead." Now you go into the courtroom and you stipulate to the facts, or you refuse to plead, and then you go through the judicial process trying to get a judicial determination. That's the way the system works. I don't care whether it's taxes or what it is. You don't think you're a taxpayer? Let me tell you. Every citizen has got to defend his position on taxes of and for himself. What people want out there, they want to join this group or organization, and they want to pay their dues to it, and then they want the leadership to go fight and argue and do their work for them because they don't want to do it. And let me tell you, that isn't the way it's done in the courts. That's the way mobs of people go to the legislature. That's the way mobs of people create monopolies. That's the way unions function, but that isn't the way citizens gain their rights. The way a citizen gains his rights is at the scene of the crime. You've got to commit the crime, or you've got to take responsibility for your actions and contend that there is no crime. Yeah, that's right. I'm prepared to defend against the IRS to Washington. I don't have any income. Okay? If I had income, I would file an income tax report. If you have income, you better file. And if you are a person who earns income, you had better pay the income tax. If you have a driver's license in your pocket, you had better give that license to the officer when he says, I want to see your driver's license. And if you've got a driver's license, you better obey each and every law pursuant to the traffic code of your state. That's right. Oh. Now you're going to look at me and say, well, you don't have a driver's license and you don't obey all the traffic laws. That's right. In the state of Idaho, I am one of the few people who can lawfully drive down the road drunk. Yeah, you heard me right. I said I can drive down the road drunk. But if you got a driver's license in your pocket, you better not drive down the road drunk. You better not drive down my road drunk. Now we're going to talk about that at great length. This subject matter of status and Toby the slave is an extremely important matter in a stratified society. And our society is stratified, and our Constitution makes provision for separate categories of persons. And when I go into the courtroom, I'm going in there to win. And there's two basic areas that I'm going to try to win in. One is my status at law, and secondly is on procedure. And that's why you're not going to be defeated unless you commit a common law crime. Now, if you've hurt somebody, if you drove down the road drunk, and you ran into somebody and you caused a damage, you've got a problem. And there's just no two ways about it. You are now guilty of causing a damage. Or you may be guilty of causing a damage, I should say that. Assuming that you're at fault and you ran into somebody, you've got a loss of life, liberty, or property. There's a corpus delicti. There's a cause of action. There's a remedy at law. And for all of those reasons, you can be tried and you can be found guilty and you can be put in the king's dungeon. Let's try number 3. Issues like Article 1, Section 10, parking meters, and counsel of your choice are just some of the issues that government doesn't want to answer because of the potential loss of revenue that would be caused by the overturning of an unconstitutional statutory consent law or legislation. You see, many of these laws are passed just to generate revenue. And so when a knowledgeable pro se goes in and says, well, that may be a good revenue-producing law, but it's unconstitutional and it can't apply to me because I'm a natural citizen. We never attack statutes and laws. We attack statutes and laws as they apply to this person in this case. Most all statutes, laws, rules, and regulations, so says the Supreme Court, have the presumption of constitutionality, and the burden of going forward and showing that they're unconstitutional is upon you, the defendant. So don't try to show that a law is unconstitutional. Just show that it's unconstitutional as it's applied to you because of your status, or because of you, because of procedure, or you because of some other reason. Don't attack statutes and try to prove that they're unconstitutional. 90% of the trial lawyers, this is number 4 in this country, 90% of the trial lawyers in this country are incompetent. So said Chief Justice Warren Burger in a speech to the American Bar Association in 1977. There are 800 rules of procedure, both civil and criminal, for police, prosecutors, jailers, interrogators, and judges to observe. You see, it isn't just the judge who commits reversible error. It can be the prosecutor, the jailer, the policeman, any number of people. 6 significant procedural errors will give the pro se a trial de novo or reversible error. Now, I'm talking about procedural matters pursuant to the rules of your state, the rules of the court, or any one significant major federal question like beating a confession out of you and using it against you in court or something like that would be reversible error. Most pro se victories come from procedural errors made by incompetent public officials. We have students who have graduated from this school a year ago who have done 6 or 8 cases and never had a jury trial. In fact, I've never won a case in front of a jury, and I'm very apprehensive as to whether or not you can win at the jury level. You need to set your theory of the case and your appealable issues way before you ever go to trial, assuming that the jury is going to come back with a guilty verdict. At the lower court levels, these admiralty juries of 6 persons are really just kangaroo courts of the old King's Star Chamber. In these type of courts, they don't even need a jury. That's just window dressing to make people think that they really have some rights that they really don't have anyway. There is no rights to due process of law, or I should say the types of due process of law that are available at the common law. They don't have to produce a 12-man jury or an indictment from a grand jury or the same type of procedural matters that you would if they would have to provide you with if you had committed a common law crime like murder, rape, robbery, or pillage. Because when you're in the equity jurisdiction of the traffic court, what you're really saying is we have a contract here and there's a penal clause to enforce, and we're simply going to enforce the penal clause. And that's an administrative procedure. And in administrative procedures, you're not entitled to constitutional due process. Oh, now somebody's going to say, well, wait a minute, then they're violating our rights. No. No, that's not true. We have a lot of patriots all over the country that think that they have rights that they don't have, which really fall under the police powers. Police powers? Yeah, that's right. Police powers antedated the Constitution by a lot of years. Police powers isn't anything new, and the first police power case that I have documented was a New York case in 1820. And the police powers can come into play and supersede what people sometimes think are constitutional rights, which are in fact not constitutional rights. For instance, the policeman searches your car and you have a driver's license. You've entered into a voluntary, regulated enterprise. And so there's a whole class of cases pursuant to the common law that say, well, you know, you volunteered into it and you don't have any rights. This is not a rights issue. This is a contract issue. The driver's license is used as a contract. While strictly speaking, it's not a contract, it's used as in that form or in that capacity. It has the semblance of a quasi-contract. By definition, a license is permission to do something that would otherwise be illegal or unlawful. Using the public road is not illegal and unlawful, and getting married is not illegal and unlawful. But once you've gotten the contract, the marriage license, to do something that would be illegal or unlawful, you're admitting to, you're in effect saying that I'm an alien. You go down to the post office and sign up as an alien. Now the Department of Immigration and Naturalization comes along, demands a show cause hearing to remove you from the country. They don't have to prove that you're an alien. All they have to do is go into court and say, which country are we going to deport him to? You've already admitted that you're an alien. You see? And that's a contractual agreement. Be careful about what you sign. You've heard the old adage all your life, don't sign anything. I don't sign anything going into jail. I don't sign anything coming out of jail. I don't sign anything in court. You know, I've had judges turn this to me and say, Mr. Gordon, I want you to sign this notice of the trial date. Well, let me see if I understand you, Your Honor. You want me to sign this document? Your Honor, I'm standing in front of this court without counsel, and I've repeatedly demanded counsel, and I don't want to sign anything without counsel. Mr. Gordon, all that is just the notification of the trial date. And I'll back up and go, wait a minute. This is a legal document, isn't it? This is a notice of a trial, isn't it? And if I'm found guilty in this matter, aren't you going to put me in jail or take my life, liberty, or property away from me? Well, yeah. Well, I don't want to sign anything unless I have my counsel present to advise me. You'll sign that, Mr. Gordon, or I'll hold you in contempt of court. I had a judge tell me that one time. Oh, let me see if I understand the jeopardy I'm in, sir. You've given me a piece of paper. Now remember, the record is turning around and around. I'm gathering evidence against this fool. I know what this is. I understand a trial date. What I'm saying to the judge is, let me see now if I understand your position. You've presented me with a legal document, and if I don't sign this legal document, you're going to hold me in contempt of court. Now, isn't that what I just heard you say? That's right, Mr. Gordon, and I'm tired of this fooling around. Okay. Excuse me, Your Honor. I just want to make sure of what I'm doing here. Now, if you hold me in contempt of court, what are you going to do to me? and I'm going to sentence you to 5 days in jail. Okay. I just wanted to understand now. If I don't sign this document, you are going to put me in jail for 5 days. Now, is that your position, sir? That's right, Mr. Gordon. Thank you, Your Honor. I'm going to sign this. Remember what I told you? Mister, when you understand power, question the authority. I don't want to go to jail. Sure, I'll sign it. Excuse me, Your Honor. And then I go here, George Gordon, signed under threat, duress, and coercion. Oh, here you are, Your Honor. I signed it. Now, when we get into the Miranda doctrine, I'm going to show you how signing anything under threat, duress, and coercion makes it null and void. Now what has the judge got? Now he's got a trial date and I don't have to appear. And if I don't appear and he throws me in jail, now he's compelled me to sign something against my will and over my objection that I didn't agree with, and now I've got him under a Title 42 lawsuit. See how nasty I am? That's right. If you can't get if the policeman won't voluntarily violate your rights, help him a little bit. Ask him some questions. You got a judge who's nasty, who doesn't understand rights, doesn't understand law. Help him a little bit. The judge here was just on the verge of creating a civil rights violation, and so what did you do? What did I do? I said, well, let me see if I understand your position. You're commanding me to sign this, right? You're going to do something bad, wicked, terrible, and awful to me, right? You got a policeman. He's out at the scene of the crime. Now, if I don't sign this ticket, now what are you going to do to me? I'm going to take you to jail. Oh, okay. Don't get upset now. Don't draw that gun and shoot me or anything like that. Now, I think I understand your position. You're going to do something bad, wicked, terrible, and awful to me now if I don't sign this, right? You see how valuable this is now if you've got a witness or two in there with you? Now, okay, I'm going to sign it. Signed under threat, duress, and coercion, George Gordon. Okay, don't shoot me, officer. Here it is. Now what's he done? He's violated your rights. Now, not saying we're going to sue every policeman. You know, some of these policemen don't deserve to be sued, and most judges don't deserve to be sued. But when you find one who's so totally recalcitrant and truculent, and just absolutely is going to violate people's rights, and he just does it time after time after time, and he doesn't even seem to want to learn, it's time that you take that judge or that policeman into the federal court, put him in the penitentiary. When one or two of those suits are filed in your county, you'll find that your public servants will stop being public officials, and they will revert back to becoming your public servants again. Okay, there's your 4 reasons why a pro se litigant cannot be defeated in the courtroom. Now, I'm not going to run over this one in great length, but take a look at this one. Here's $1,240. Take a look at that. Here's the paper that says at the top of it, here's the cost of a one-day trial to the jury in the traffic or magistrate's court. Just take a look at that. I don't know what it is in your state, but this will give you an idea of what it costs and why it is that the citizen can go into the courtroom with a smirk on his face and say, what are you going to do about it? Now, I'm not suggesting that you be nasty. You know, if you go into the traffic court and you have a driver's license and you want to plead guilty and you just want to pay the $40 and walk out the door, listen, I've done that for years and I understand exactly how that works, and I don't have any problem with that whatsoever, and you just do whatever you want. What I'm suggesting is that you don't have to do it. You cannot be compelled to do that. And that it costs your government so much more than it costs you. You know, the average guy goes in and says, well, I'd lose a day off from work if I went and fought this, or $200. It cost me $200 off from work, and so therefore I'm just going to pay the $40 fine. Your government's going to pay about $1,200 to $2,000, and they don't want to spend $2,000 any more than you want to spend $200. So it's a matter of who's going to back who down. You're going in there, you know, it's like a poker game. You're sitting over here, you know, I'm going to raise you another 50. You know, and you're sitting over here with all the trump. They can't defeat you no matter what they do, and it's going to cost them $2,000 to lose, and it's going to cost you $200 to win. I'd rather spend the $200 a couple of times and win, and let them know that every time we have a confrontation, we're going to go to Washington with it, and if we go that far, it's going to cost you $60,000, not just the $2,000. And make them back down, because then after a while you start picking up all these $40 bills. You know, the other day I had a hospital call me, and they told me they wanted me to pay them $8,000. No, it was a collection agency. That's what it was. Some collection agency called and told me they wanted me to pay them $8,000. And I said, why do you want me to pay you $8,000? Here's the scene of the crime. Here's my first confrontation in a legal matter. If you owe somebody $8,000 and you don't pay, isn't he going to take you into the court and take you before the judge and exact the money from you? So let me give you a little background, and I'll show you how to make some money in a hurry, whether it's in the traffic court or whether it's a bill collector or who it is. I don't care if you're a farmer and you're sitting out here and you got a farm and a $400,000 mortgage on this farm and you signed all these contracts. They can't collect it. I'm not saying that you shouldn't pay it if you owe it, because, you know, if you went in and you borrowed some money and you owe it, or you borrowed somebody's lawnmower, I think you should return it. I think that the 10 Commandments are in full force and effect. Well, at least 9 of them. I mean, nobody wants to keep the 4th commandment, and I understand that. But I'm saying, well, you know, whether you keep 9 or 10 of them. There's one that says, thou shalt not steal. I think that's a good commandment. I think everybody should pay their bills. But in our state, we have a unique situation out here. It's called abuse and child neglect. Now, I happen to be a free and natural citizen, and I happen to think that I'm the type of person who has the capacity to determine whether or not he should go to a naturopath or go to a medical doctor or go to a bone specialist. You know, I think I can decide that for myself. My government doesn't think I can do that, because most of the people in the state of Idaho are subjects and members, and they are not sovereigns. And so therefore the government here, our state legislatures, pass some laws. And I have a little girl, and she had this lump on her back which was determined to be a strep infection, and it was some kind of a bizarre type thing, not really life-threatening or critical, but it was painful and it needed some attention. I thought that she'd had an accident and hurt a bone, and I took her to a bone specialist, and he said, gee, I can't do anything for this. You better take her to the hospital. Now, once a doctor has looked at your child under the age of 16 or 18, I forget which, and tells you that you need to take this doctor to a hospital, or this child to a doctor or a hospital, it could become child neglect. And in this state, under Chapter 18, Section 1501, I could be put in prison for 1 to 10 years. That's a felony. So I had to go to work, so I had a friend take my little girl over to the hospital, and they went in the hospital, and they admitted her, and they put her in there, and they started giving her some treatments. And I really didn't want that, because I'd rather take her to a naturopath and have her cured than to have her taken to a hospital and have her practiced upon. But, you know, the law is the law. So the next day I went into the hospital, and I said, have you got my little girl in here? Yeah, we do. Do you know what's wrong with her? No, we don't. Oh. Are you going to find out what's wrong with her? Yes. How long is it going to take? We don't know. Let me ask you a question. Are you charging me money for this? Well, certainly we're charging you money for this. Oh, just asking. How much money are you charging me? Well, the bill's $500 so far. Oh, let's see now. We brought her in here at 7 o'clock last night. It's 9 o'clock this morning, and the bill's $500, and you don't know what's wrong with her. Okay, just asking. Let me ask you another question. Are you going to keep her here if I tell you I want to take her home? Oh, you can't take her home, Mr. Gordon. Oh, okay, just asking. Well, I just want you to know that I can't pay you that $500 because I don't have any money. And I think I better take my little girl home and let her die there. Mr. Gordon, why, you can't take that sick child out of here. We won't allow you to. Oh, let's see if I understood you right. You're telling me that you're not going to allow me to take my little girl out of the hospital. Is that what you're telling me? Yeah, that's right. Oh, okay. When's visiting hours? Oh, at 2 o'clock in the afternoon. Thank you very much. I'll come back at 2. So I came back at 2 o'clock every day, and we went and visited our little girl. And she was in there for about 7 days. And gosh, these hospitals are really expensive. They have nifty machines in there. And this one machine they put her into, it's called a CAT scanner. She had an infection on her back, so they wanted to take a cross-section type x-ray. And so they took about 50 x-rays. She'll probably die from cancer by the time she's 14. But leaving that question aside, they put her through this CAT scan machine. They charged $1,645 for that. That's right, $1,645 for that picture. I asked them if they found out what was wrong with her the next day after they took the picture, and they said no. You spent $1,645 and you took a picture and you still don't know what's wrong with her. No, we don't know what's wrong with her. And they gave her antibiotics and they put her in a private room because they thought she had bubonic plague or some other wild disease. And okay. And this went on for about a week, and she's in the hospital about a week. And finally one day I went in there and I said, excuse me, my little girl seems to be a little better now. Would it be all right if I take her home? No, you can't take her home. Why is that? Because you haven't signed the admittance papers. Oh, what? Watch the fun now. Well, let me see if I understand you. Are you telling me that if I don't sign these admittance papers down here, I can't take her out of the hospital? That's right. Okay. Well, if that's the case, are you going to raise her in my religious faith? And is she going to live here for the rest of her life in the hospital? Or does she go to some other home? Or do we have any visiting privileges? Is there anything like that? Conversation broke right down. This poor nurse, she just couldn't cope with this. She said, here again, here's your scene of the crime. Here's your confrontation. You're laying facts. You're asking questions, aren't you? And aren't you doing this in front of a couple of witnesses? I don't talk to anybody unless I have a couple of witnesses. You know, when I go up to serve paper on the court, I say, hey, you and you, let's go up and serve some paper and spread some stark terror. So I went down to the admitting room and I said, hi, got a nice lady in there, very nice lady. She's probably got a nice husband and a patch of grass in the front and a mortgage, you know, just like all the rest of us. Hi, sweetheart, gee, how you doing? My little girl is Elaine, and she's up there on the 4th floor, and I want to take her home, and there's this nurse up there, and she told me that I couldn't have my little girl back unless I came down and talked to you. And so that's why I'm here. I'm here to talk to you. And this lady pulls out all the, you know how these administrators are. I mean, she pulled out a stack of paper and forms, and she dropped them in front. She says, fill all these forms out here, Mr. Gordon. And so I took the first form. Legal documents now. I don't like to sign things, you know, that I don't know what I'm signing. So I took a look at it, and I looked at it, and I go, Would you mind if I changed some of the terms and conditions of this contract? And this lady looked at me with absolute, total, incredible incredulity. What did you say, Mr. Gordon? I said, would it be all right with you if I changed some of the terms and conditions on this contract because I don't like some of the terms and conditions? Absolutely not, Mr. Gordon. Why, this form cannot be changed or altered in any way, shape, form, or manner. Oh, okay. I handed it back across the table and folded my hands and looked at her. Well, Mr. Gordon, you have to fill those out. What are you going to do to me if I don't fill those out? Well, Mr. Gordon, we can't complete the admittance and we can't complete the financial arrangements if you don't fill those out. I don't want to fill out any papers. I don't want to complete the financial arrangements, and I don't want to complete the admittance form. But you have to, Mr. Gordon. Why? What are you going to do to me if I don't? Mr. Gordon, this is highly irregular. And she left the room, and then some other lady came in, and she told me the same thing. I said, let me see if I understand this. Are you telling me that you're going to kidnap my kid if I don't fill out those forms? Mr. Gordon, you're becoming, I forgot how she put it, you know, insane. This is ridiculous. This whole conversation's crazy. Oh, okay. Well, am I excused? Well, we'll talk to you later. Thank you. And I left. Well, when you leave the administrator's office, what do? I went back up to the 4th floor, and I walked over and I said, can I have my little girl? Have you filled out all the forms and done everything that's required of you downstairs? Catch the wording. I think I have taken care of everything that can be taken care of today downstairs. Were you going to let my little girl out, or did you want to keep her? Oh, no, she can leave. So I took my little girl and left. Then I started getting these bills. People started writing me bills. They said they wanted me to pay them $8,000 or something. Wait a minute. I didn't want to take my little girl to the hospital. I wanted to take her to Dr. Maxfield, who's locked up in the penitentiary because the medical association and the medical profession here in Idaho doesn't want naturopaths competing with them. They have a monopoly. The medical profession has a monopoly here in Idaho, and you have to go to doctors and hospitals, and you have to have insurance, things like that. Well, the other day I got a notice from some lawyer, and he said he was going to take me to court if I didn't pay that bill. But he said I had one last chance, and if I would go out to this collection agency, perhaps we could avoid this costly litigation. So not wanting to get involved in any costly litigation with my government or with the medical profession, I went right out to that collection agency, and I took 2 witnesses with me, which is my custom. I took Idaho statutes out and the child protective laws, and I walked in and I sat down and I said, you know, I'm getting a bunch of bills, and I don't want you to send me any more of these bills because they're disturbing me. And they're causing me great consternation, and I don't want you to send them anymore. I don't owe this bill, and I don't want to hear about it anymore. Oh, now, Mr. Gordon, I'm sure that we can work this out. Of course you owe this $8,000 bill. Oh, let me ask you a question. Maybe I do owe this $8,000 bill. Maybe I am off the wall and out to lunch and don't understand the law and what's happening here. Would you please show me the contract? Conversation broke right down. Oh. Well, isn't there some kind of an agreement that somebody signed to obligate me to pay this? Well, now, you know, I've looked through the file, Mr. Gordon, and that does seem to be conspicuously missing for some reason. Perhaps the hospital forgot to send it. Oh, yeah, perhaps they forgot to send it. Maybe that's what the problem is. I don't know. All I know is that I don't want to come back here again, and I don't want to be inconvenienced again. So let me tell you what my status and let me tell you what my position is at law, and then maybe you won't need to call the hospital and we can just forget the whole thing. Mr. Gordon, this is highly irregular. I don't understand. Let me see if you can understand this. So I whipped open the Idaho Code and I read it to him. I opened up to the child abuse statutes, and I said, now the medical profession in the state of Idaho has created through statute a monopoly. If a parent can see a bruise on a child, he has to take the child to a doctor or a hospital. If there's a broken bone or there's anything like that, I have to take him to the hospital. And that's what I did. My little girl had a rise in the flesh, and I quoted the exact statute, bruises or a rise in the flesh that's unexplained. And so I just did what the law told me to under Idaho Code 16-1616, and I took her to the hospital, or I had a friend take her to the hospital, and they looked at her, and I told them plainly at the time that I didn't have the money and I couldn't afford to pay them, and I didn't want to be there, and I was there against my will and over my objection pursuant to the law. I didn't have any choice. My government had decided for me what was good for me and what was bad for me. And being a coward and being timid, I was afraid to assert my constitutional rights, and so I just acceded to the statute and obeyed the law. And the guy listened to me patiently. I said if I had failed to do that, I would have been guilty of a felony and prosecuted and put in the penitentiary, and I was afraid of my government, and I was afraid they were going to put me in prison, so I took my little girl to the hospital, which is what the law demanded that I do. Now, I guess the constitutional question here is, can the state of Idaho pass statutes compelling citizens to purchase services or goods that they don't want against their will and over their objection, and then bring legal action against them and take their property from them against their will and over their objection to satisfy said debts. Conversation broke right down. He said, Mr. Gordon, I'll get back with you. I'll concert, but, you know, it just goes. And I closed by saying, if you bring action against me because I obeyed the law, I'm going to construe that as a vicious and malicious attack on my character and my person and my credit. And that you're doing so maliciously and without foundation in violation of my civil and constitutional rights as guaranteed by the 1964 Civil Rights Act and the Civil Rights Act of 1871. And then I will have to prefer charges against you criminally in addition. Now, do you understand my position clearly? The man evidently understood my position because he said, Mr. Gordon, I think I'll just send this back to the hospital and they can do with it whatever they want. That's right. Now, I'm not suggesting to you that you don't pay your hospital bills or you don't pay your doctor and etc. I don't know. What I'm suggesting is when your government passes a law and compels you to buy something, your government is violating your basic rights unless you've signed some contract somewhere along the line and agreed to purchase those goods and services. Now, in the case of insurance, if you've got a driver's license, you better buy insurance because you're engaged in trade, commerce, business, and industry out of your own mouth. They don't need any intent. They've already got you. You've got a contract in that driver's license. Now, the subject matter at the hospital was, had I signed the admittance papers and signed all of the contracts and agreements, why then, you know, I'd have to pay. So you see what they do? They pass laws of a commercial nature. And then they tell you it's the law and you have to do this, and then when you obey the law, you have volunteered into a contractual agreement. Now, you didn't know that's what you were doing, but that is what you did. What you have done or what you did. All right, now if that's some of your problem at the scene of the crime, make sure that you lay it out in spades right there. The worst they could have done is said, no, we will not admit your little girl. Oh, I see. Let me see if I understand your position. My little girl is dying, and she has some kind of disease that we don't know and we don't understand what it is, and it could be bubonic plague or some other communicable disease. And you're telling me that because I'm poor and don't have the money and won't fill out these papers that you're going to send her away and let her die. Is that your position? Okay. Well, after all, the hospital is the one that wanted those statutes passed, didn't they? For the health, safety, protection, and welfare of the people. In other words, you see, the people aren't capable of deciding for themselves what they want to do with their own flesh and blood, what they want to do with their own bodies, and so we have to have laws that tell us, yeah, you have to go to the doctor. You have to be cut and burned, poked at. We're going to shoot you full of snake venom and monkey pus whether you like it or not. Well, I just happen to be one of those kind of people that figures that he can decide for himself what he wants to do and what's best for him. I don't know about you. You'll have to decide for yourself whether your government can do better for you, what need be done, or whether you can do it. But in my case, let me tell you, whether I'm dealing with the man in the hospital or the lady in the hospital or the man out on the beat, I don't have any want of words, and I don't have any problem understanding the law. All right, now let's go out to the scene of the crime of a traffic case. And I like to use traffic cases pretty much because every one of us has some kind of experience with the traffic cop, but we don't have too much experience necessarily with commercial contractor paper or maybe a real estate deal or something on that order. You may not have been arrested by OSHA lately, but you may have been given a ticket by the local traffic policeman. Now, when you're driving a car and you have a driver's license, you don't have any issues at law. You only have issues of procedure. Now, the policeman has to obey the law, and he has to obey the standards and statutes, whether they're civil or whether they're criminal, or whether civil rights or natural inalienable rights apply. In some states, traffic offenses are not criminal. They've been decriminalized, and they have a hybrid morphodite type word that they use called infraction. Now, the infraction can be used against you because you have the driver's license, and it is, in fact, a commercial contract in interstate commerce affecting a public interest that comes under the police powers in summary proceedings. Just like a taxpayer goes into the tax court because it's a summary proceeding because he's a taxpayer. When you get into that court, you don't need a jury. You just need a clerk up there to collect the money. That's all there is to it. Now, if you're in a state that doesn't have the infraction law yet, then it may be a criminal matter, and in Idaho at this moment in time, traffic matters are criminal. Therefore, they're misdemeanors. If they're criminal and if they're misdemeanors, then they come under the rules of criminal procedure, not civil procedure. Now, the policeman catches you going down the road, and you're driving at 80, and it's a 55-mile-an-hour zone, so he turns on the lights. And here's the way this scene comes down. You're driving along. You look in the rearview mirror. Gosh, honey, there's an emergency vehicle behind me. I'll bet you he's going to an accident. I'm going to pull over to the side of the road because that's an emergency vehicle and he needs to get to wherever he's going. And so you pull off to the side of the road. And you expect him to go, Nyam! But he doesn't do that. Gee, hon, he stopped behind us. I wonder why he did that, and I wonder what he wants. And after all, what would you think? The issue, you don't know. You're just totally dumbfounded. You don't know what this is all about. Policeman comes up to the window. Hi, gosh, how you doing today? Good to see you. And the policeman says, I want to see your driver's license, registration, and proof of insurance. Isn't that what they usually say? Gee, officer, why do you want to see that? I mean, did you want to see my marriage license, my baptism certificate, and my social security card? Why would you want those particular documents? What gives you the authority or the power to make these kinds of demands upon me? Are you trying to be smart with me? Sir, I don't know what your vernacular cliche is trying to communicate. All I know is you've made a demand upon me, and I'm asking you in plain, understandable language, what is your probable cause for making this intrusion into my private life? Now the fellow's going to look at you. Well, I'm a policeman. You're driving 80 miles an hour down the road, and I want to see your driver's license, registration, proof of insurance. Oh, let me ask you a question, officer. Are you making this stop pursuant to the Terrier Rule or pursuant to the Miranda Doctrine? Wait right here. I'm going to be back in a minute. Now he goes back to his patrol car and he calls and he says, I got one of these constitutionalists up here, and he stopped and he won't give me his driver's license and he won't cooperate. Now this policeman is hidden behind these giant glasses that are totally black. He's confronted with the master, and he's the slave, and he doesn't quite know how to deal with the master, and so he wants to hide behind these glasses because otherwise his eyes will shift all over the place, you see, because he's really nervous. And that's his crutch. He needs that. Don't take that away from him. Poor fellow will melt like a jellyfish in the hot sun. He comes back to your car, and he says, Sir, do you have a driver's license? And, well, now, I'm not sure I want to answer that question because it could be an incriminating question in a criminal investigation. Is this a civil or criminal matter? It's criminal. I see. So you're in the process then of making an interrogation pursuant to a routine traffic stop, which is a custodial interrogation. Is that your position, officer? Conversation starts breaking down rapidly when you start using language, so you may have to put this in simpler terms. It's like, what did you stop me for? Oh, you stopped me because I was speeding? Now, you're making some allegations here. Is this civil or criminal in nature so that I'll know what kind of jeopardy I'm in as to whether or not I want to answer your questions? Sir, I'm going to write you a ticket for speeding, being an uncooperative citizen, resisting and delaying an officer, no driver's license, no registration, and no proof of insurance, and I may have to arrest you and take you to jail. Okay. Now, let me see if I understand this correctly. You're telling me that the probable cause for making this Fourth Amendment intrusion now was that I was exceeding the speed limit. Is that your position? Sometimes they'll come unglued right here and walk off. I've had these guys threaten me. I've had them open the door and yank on me. I mean, you never can tell what this guy's going to do. He may pull his gun out and commit suicide right there in front of you, and there you've got a real messy, gory problem. And I don't know what's going to happen. All I'm telling you is that here I am. I'm the sovereign citizen. I want to know, why are you doing this? What's happening here? Now, other people tell me, and I've had policemen say, you know full well what's going on here. You know that this is, as if I'm some kind of a knowledgeable person in this traffic process. I don't know what contractual agreements you have with insurance companies, traffic courts, and your legislature pursuant to using the road. I know what my common law rights are. I'm not really sure I know what these contractual specific performances are. Now let's assume that this policeman is somewhat literate and he can kind of understand. Maybe he's talked to another person who has some rights. These policemen don't understand people who demand constitutional rights. I know that in this county there's about 200,000 people, and I doubt seriously if there's 100 people in this county who know and understand their rights and demand them. So, bear with this poor policeman, because after all, he doesn't even know what's going on here. He's never heard this before. He's been to the government schools. Well, sir, do you have a driver's license? Well, let me simplify this for you, officer. I want to, at this time, I think I better put the exclusionary rule into force. I don't want to answer any questions, and I demand all of my rights at all times, including my right to time. I waive none of my rights at any time for any cause or reason, and that includes my right to counsel of my choice pursuant to the Miranda Doctrine, and I demand counsel present during all stages of this interrogation. Are you prepared to move forward with an in-custody interrogation at this time? That usually blows them away. This guy's sitting here, wait right here, and he'll go back and talk to his field commander. About this time, if you're in Boise, Idaho, there'll be about 5 police cars coming. I don't know what these guys do with bank robbers and criminals, but it takes about 5 Boise policemen to give a traffic citation to a constitutional person who's demanding his constitutional rights. I would imagine if he had a bank robber out here, it'd take 150. I know it takes that many to give a man a ticket for a traffic infraction or a traffic violation. So he comes back up about this time as field commander. Now they're going to double team you. So he'll come up and he'll start making demands upon you. And they'll tell you they're going to take you to jail. They're going to intimidate you. I'm going to take you to jail. Oh, well, let me ask you a question. Before you take me to jail, will you willingly and knowingly violate my civil and constitutional rights? Are you doing this maliciously? And he'll deny that. Oh, I'm not violating any of your rights. Okay. I just wanted to know if you were going to. Because under Idaho law, this man told me that his probable cause was that I was speeding, and pursuant to Title 49, Section 1109, you cannot take me to jail. If you're going to arrest me, you have to take me to a magistrate, and I demand that you take me to a magistrate in the event that you feel it necessary to arrest me. Now the guy looks at you like, uh-oh, now this guy's quoting law. You ever had a policeman quote law to you? A policeman can quote regulations and statutes. The policeman doesn't know or understand law, so I'm not really quoting law. I'm just telling him that that's in your little book there. Go back and get your little blue book out and flip it over to 1109, and you'll see it in there plainly. It says that except for drunk driving, manslaughter, hit and run, and 2 or 3 other felony-type crimes where there is a corpus delicti, you cannot take me to jail. You have to take me to a magistrate, and that's what I'm demanding. Now, are you going to do that? Look, Mac, all we want to do is give you a ticket. Oh. Now, let me see if I understand this. This man tells me that I'm guilty of about 5 or 6 or 8 offenses. I don't even know how many. All I know was I was driving down the street and this man came up behind me and he's been harassing me now for about 15 minutes and I'm kind of getting tired of this. And are you his supervisor? Yeah, that's right. I'm the field commander. Oh, well, let's see if we can get some facts here. Now you pull out your pad and you flip it over here. You see, you're Field Commander Jones, is that right? And your badge number is 7214. And you start going around to all these policemen and you take down the car numbers, the badge numbers, and the names. All right? Each and every one of these people now is a material witness and you want them in court. You want them in court for 2 reasons. One, you're going to demand a probable cause hearing. In this state, they hold them incognito. They hold them what we call ex parte. You can't be there. So there's your first constitutional due process of law that's violated. You're denied a right to face your accusers in front of a judge. They always find probable cause. Never seen a case yet where the judge wouldn't find probable cause. Why wouldn't he? The officer comes in and says this guy's guilty and the guy's not even there to say, no, I didn't do it. No evidence, no proof, no witnesses. They don't do anything here. They just haul you into court. Okay. Well, if you got a driver's license, yeah, they can do that. But if you don't have a driver's license, and remember, up to this moment in time, this guy doesn't know whether I got a driver's license or not, does he? I haven't told him. He keeps asking me to give him one. He keeps demanding that I give him one, but I don't tell him whether I've got one or not. Now, do I? See, I've learned lesson 1. Rule number 1 of a pro se litigant, I can keep my mouth shut. But I can also walk and chew gum, so I can also hold a conversation without telling him anything. That takes a little more effort. So now, all of a sudden, I'm gathering evidence. If you don't think that makes policemen nervous when you're taking down names, numbers, and evidence. Let me see if I understand your position. I asked you if this was a custodial interrogation, and I don't think you told me. Am I free to leave? No. Okay. May I? You're Field Commander Jones? Okay. Field Commander Jones says that I'm not free to leave. All right. Are you going to ask me questions here? Well, just, enough to fill out the tickets. Well, you're going to ask me for what? Well, are you going to identify yourself? Well, I don't know. What relevance does it have who I am? You could prosecute me as John Doe or Sam Smedley. Is there some reason why you want me to identify myself? Yeah, if you don't identify yourself, we're going to arrest you. Oh. Well, in that case, then I don't think I'll identify myself. I'm interpreting that as a threat and a violation of my constitutional rights, and pursuant to Brown versus Texas, I don't think I have to identify myself. Now, did you want to arrest me and take me to a magistrate, or are you going to arrest me and take me to jail? See where you got him now? Now, you may want to identify yourself because you may not want to go to jail. I don't know. It just depends. When they deal with me, I usually just empty my pockets. Hey, fellas, I guess I'm going to jail. Let me see if I can gather some more evidence here, officer. What are the charges? Speeding? Resisting arrest? Oh, wait a minute. Resisting arrest? What do you mean by resisting arrest? Let's see. No, you're not resisting arrest, but you're obstructing and delaying an officer. Excuse me, sir. Would you explain that to me? What is your motivation for charging me with it? Now they don't want to talk to you. And they'll just shut up and they'll either arrest you and take you to jail, or they'll say, if you'll identify yourself and agree to appear in court, I'll just give you a ticket. After your first 3 or 4 encounters with the police, they won't want to arrest you. They don't need to ask you who you are. After the first 3 or 4 encounters, they'll know who you are. Now watch how this goes. Now he's writing out the ticket. He says, well, what's your name? Let me ask you a question. You're going to arrest me if I don't tell you my name. Isn't that what you told me? Yeah, that's right. If you fail to identify yourself, I'm going to arrest you. Okay. My name's George Gordon. Okay. Next. Now, where do you live, Mr. Gordon? Are you going to arrest me if I don't tell you where I live? If you don't cooperate, I'm going to arrest you. Okay. 1205 North Roosevelt Street. Okay. Now, I've identified myself and I gave you my address. Okay. What's your date of birth? Hold it. Now, you're going to send me a birthday party. Are you going to throw a birthday party from here? Send me a birthday cake. Mr. Gordon, you're just really getting on my nerves, Oh, wait a minute. I'm getting on your nerve. Wait a minute. If I'm bothering you in some way, you are excused. You have my permission to leave. You do not have to stay here. But see how that conversation breaks down? Here's this guy. He pulls up behind me. He stops me. He intrudes in my life and then tells me I'm obstructing and delaying him. You see how insane that whole conversation is? So while you're there talking to this fool, make sure that you're there gaining information. You want from him admissions. You want him to talk. You want him to talk in front of his fellow officers. You want him to talk in front of your witnesses, so that when you get into the courtroom, you put this other officer on the stand, and the conversation goes like this. You say, now, on February 5th, 1982, did you have occasion to see the defendant at the corner of Fairview and Liberty? Yes, I did. And what did you observe there? Well, I observed Field Commander Smedley over here giving him a ticket. I see. And did Field Commander Smedley ask Mr. Gordon his name? Yeah. And did Mr. Gordon ask him if he was going to do something bad, wicked, terrible, and awful to him if he didn't answer? Yeah, he said he would arrest him. Let me ask you a question. Do you always arrest people who won't give you their names? Oh, yes, we always do. Now, where have you got him? In violation of Title 49-1109, don't you? You see how you get him on the witness stand and you start getting admissions and confessions, and then it's with that transcript of that trial that you use as the evidence for the complaint that you go into the federal court with. See the way that works? See how simple that is? Do you see how important the scene of the crime is? When I'm at the scene of the crime, I'm not the victim. I'm the interrogator. I'm there gaining evidence. And when the policeman is sitting there wondering whether or not he's going to take me to jail, I help him along a little bit. If you take me to jail, you'll be in the process of committing a crime. Did you want to go ahead and commit that crime, or did you want to back off and get some legal counsel first? What am I telling him? I'm telling him he's got a right to legal counsel before he goes forward with the crime, don't I? Isn't that what Miranda tells me I have to do? If the policeman has to read you your Miranda rights because he's going to arrest you or give you a ticket or do something to you because of some alleged crime, don't you then, the peace officer, the citizen, then have to read the policeman his rights and tell him he has a right to counsel and he has a right to remain silent, and anything that he says can and will be used against him in a court of law? That's right. Yeah, you have to do that. And that's what you do every time you have a confrontation with your government officials. It doesn't take them very long until they figure out, wait a minute, this guy is either a very knowledgeable, honest, forthright, upstanding citizen in the community, or he's a very tricky adversary who is a real heinous criminal that we've really got to be careful of. It doesn't make any difference in either case. You're in the driver's seat and you're in total control, aren't you? You know, if you can't seize control, a salesman is taught right off the bat that whenever he's conducting an interview, he has to maintain control of the conversation and direct the operation. Well, that's all the policeman is a salesman, and you're a customer, and you're out there, and he's making a contact with the public, and his job requires that he make 4 of those contacts per shift. And you're just a contact, and he doesn't know if you're going 80 or not. He just said you were. I mean, half the time these traffic cops out here are just giving tickets because they need to rack up points. It isn't because these people are doing anything wrong or that they're heinous criminals. They're just called criminals so that they can go through the criminal justice system so that they can make money for the traffic court. Traffic cops are there to protect the claims window of the insurance industry. They're not there to promote law and order. That's a private police force that's there to enforce private contractual law paid for by the public. I think those insurance companies are very clever doing that. I wish I had a business where I could go to my government and pass a law and compel everybody to buy a waterbed. You know, I used to be in the furniture manufacturing business, and I tried for as long as I can remember. What I wanted was a waterbed bill. I wanted the state of Idaho to pass a statute and make it a law to require every person to buy a waterbed and to carry proof of waterbed ownership with him at all times under penalty of statute, criminal misdemeanor. And I wanted to do it under the police powers for the health, safety, and welfare of the people. I had nothing in mind but your best interest. Because, you see, our state insurance compensation fund pays out $3 million a year in back-related injuries and and insurance claims, and I just know that if I could get everybody in the state of Idaho sleeping on a waterbed, we'd cut that in half and save $1.5 million a year. Now, don't you want to save $1.5 million a year, Mr. John Q. Public? Now, the answer to that is, what do I care? Think about it for a moment. Let's have a little lesson in logic. The insurance company insures your house, right? The bank has a mortgage on your house, and because of the mortgage, they require you to have fire insurance on your house, right? Don't they require you to have full coverage on the house? So your house is worth $50,000. You go in and pay $5,000 down, you buy the house, and you have a $50,000 insurance policy. Isn't that the way that works? Okay? Now, you have insurance on the house. Who cares if the house burns down? You? Now, the average John Q. Public, he's been brainwashed by watching these TV set and Fireman's Fund for so long, he says, oh, God, yeah, I'm just scared to death my house is going to burn down. I'm not. My house can burn to the ground. I don't care. When my house burns to the ground, my insurance company comes over and gives me a check for $50,000. Now I can move to a better neighborhood. Who cares if the house burns? Just two people. The bank and the insurance company. The bank just cares because they're going to lose $45,000, and the insurance company because they stand to lose $50,000. So they don't want your house to burn. So what do they need to do? They need to go to the legislature and get the fire alarm law passed and the smoke detector law passed. And they need to get the fire district law passed. So there's private commercial contract going to a public corporation, your state government or your city government, to create a fire department, a fire district. Who pays for that? Who pays for the firemen? Who buys all those shiny fire engines? Oh, you do. Why? Why do you want to buy shiny fire engines to protect the bank and the insurance company? You've already paid them the premium for the policy. You're already paying interest on the money. Why would you want to then protect their potential loss? Didn't they agree to assume the loss if you'd pay the premium? Isn't that the way that works? And so, here you have this strange anomaly. Your government passes the law because the insurance company and the bank wants it, and so they have the law that requires you to buy the insurance. Now you buy the insurance, and the insurance company says, now what we need is a fire protection district so we can't have any loss. If you can't have any loss, what do you need the insurance for? Somehow, the logic of that escapes me. If I've got a fire engine, I don't know of a single house in this city that's ever burned to the ground. See, none of them burn to the ground. They just have a little fire and then it burns them up. And then instead of a $50,000 loss, there's a $5,000 loss, but you're paying insurance on the full value of the house, which is a $50,000 loss. Why don't you just pay insurance premiums to cover a $5,000 or $10,000 loss? So here you are, the taxpayer, paying for the fire district, and also paying the insurance company to assume the risk on your house. And after the insurance company has taken the risk on your house, they have eliminated the risk on your house because now they've got a fire district. Does that give you a clue as to how the auto industry works or the auto insurance industry works? And how the traffic court works? The traffic court is simply there to enforce compliance to regulations to prevent losses on the roads.